want to speak to an agenda item, that is possible. Okay, when we do the agenda items, if you have a question, you can raise your hand there. If you have something you want to say that's not on the agenda, please sign it. Okay?
It's on the agenda, so don't.
It's on the agenda. You don't have to.
That's okay. It's okay. We're good at that.
I'm going to call the June 28th Town Council meeting to order. Please stand to pledge the flag. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. I'd like to make one other announcement regarding public comments. Because it is public comment and it is not on our agenda, we cannot answer you or speak to it. So we just quietly and attentively listen to you, make notes, and if we think it needs to be a further agenda or a future agenda item, we do address it at that time. So that being said, Mr. Peterson, will please state your name and address?
Yes. My name is Robert Peterson. I live on Foster Center Road. And I have just a couple of things I'd like to share with you. This is with regard to a...
I'm sorry, you have to wait for Mrs. Peterson.
Mrs.
Oh, Priestone, I'm sorry. Firestone. Flintstone. Yes. I'm sorry.
This is with regard to the agenda item, which you have for old business regarding groups related to the town. And I'd like to just make some suggestions to you as you consider that today. First of all, we all know that Foster is a volunteer town. We cannot exist without volunteers. However, those who take care of fire and safety are special volunteers. And this is something that I would like to call to your attention. You cannot treat them as you would volunteers who just serve on a committee or something, but those who are involved in fire and rescue require special training. They do deal with human life and property, and we have a special duty to them because of that service which they give to us. Number two, I would like to suggest to you that you make better use of the quarterly reports. Now, I've come to council meetings over the years, and I know that the 3 fire companies and the ambulance corps have been asked to make quarterly reports to the council. But I would suggest that you consider making better use of these. There are 5 members of the council. There are 4 stations 1, 2, and 3 in the ambulance corps. And I would suggest that you visit them on a quarterly basis. You don't have to go all the meetings, I'm not talking about that, but visit them, go over the quarterly reports with their officers and develop a rapport with the units. I think that if you had, now I'm not talking about you personally, but if the council had done this over the years, I think a lot of the problems that were involved with the status of Station 2 could have been avoided. Now, another suggestion I have for you, and that relates directly to the issue tonight. I suggest that all changes in directives, if you can give directives to a volunteer, just remember that. It's very difficult. You cannot order a volunteer. You can encourage or you can lead. But all changes in directives should be delivered in person. I know that there was a directive out on issues that were just sent as an email, and that in order to have volunteers cooperate, they have to have understanding, and you have to have understanding with them. Another thing I'd like to suggest, now on the agenda tonight you're having recognition for Sharon Carter, which is very good. But I would suggest that you think more seriously about many of the things that go on in the fire and rescue. How about people who complete EMT training? Should they be recognized by the council? It doesn't have to be a big chart or an award or a piece of paper, but just a visit and a pat on the back. That means that you have to have some intelligence of what's going on in the... I know that in Station 3, 3 young men under the age of 18 who are youth members went and took a course in firefighting. It was taught in Warwick. They finished it, and they've been an addition to the department. They need to be recognized by more than just the unit itself. The last one is my suggestion about shared liability. In almost all cases, you own the trucks, but they are 503B or whatever they are, organizations. But your name's on the truck. You have some liability there too. And I know that in Station 3, about 25% of their budget goes into paying insurance and liability. Insurance for the people who actively go fight fires and do other things, but also liability. And that's something that the council needs to share with the departments. Talk about shared liability. You have an engineering board, which is really a coordinating board for the fire and rescue. So those are the things that I'd like you to consider tonight when you consider those things. And remember that they are special volunteers in that they have training and they have a very special job in the town. And as a council, I hope that you will work to build trust with them. And the next council after this will continue. Thank you.
Thank you, Mr. Peterson. Dan Davey? Would you please state your name and address, please?
My name is Daniel Davey. I live at Fremont Highfield Road, Forest, Rhode Island.
Thank you.
I'm here for the farm next door to my house that we voted against, or the zoning board voted against giving this man any more permits or whatnot to continue what he's been doing. I live right next door. He's been doing it quite a while. Nobody said nothing. I've got pictures of trucks going in and out of there when it was supposed to be a cease and desist. I'm just also concerned that I understand that this meeting was called to overturn that. If I'm wrong, let me know. But myself and a lot We moved here for the serenity and the quietness and the clean air that we won't be getting if 60 trucks an hour fly by my house and everybody else's, and through that intersection, and with the school and fire department right there. I don't feel it's right. I don't feel that we should be opening this matter up again. I just don't see the reason for it. The people spoke, the people don't want it. The zoning board voted on it. Why are we going there again? I don't see why we're going there again. My wife has asthma. She won't be able to open the windows and enjoy the fresh air. With all this dust, they're not going to be watering down the whole area. They say they are, but they haven't done anything they said they're going to do so far, and everybody knows that. Why are we allowing rock crushers when they said they weren't going to have rock crushers? We're going to let him do everything he wanted to do before. We all know it's not going to be a horse farm. We all know that. Something else is going to happen. I personally think they're going to build there. Once they can't do anything else, they're going to build, and they have everything in position. You guys have no other choice than to give them what they want. And I hope you people on this board are for the people in this town. And you are concerned with what we want and our needs, and the money we put into our properties and our homes in order to have a nice place where our kids can grow up or take over our own place, or for the future generation to enjoy. All the abutters, I'm an abutter, there's a lot of other abutters, I see a few in the audience, that why aren't our concerns being met? We got up there and spoke, I spoke at every meeting, and we thought you heard us. Evidently, something else is this. I don't know what it is, I don't know what's going on, but we definitely aren't happy with this. We don't want it. I would think that what the people want should be good. You know, our values are going to go down. We buy these houses, we get ready to retire, we want to sell our home and be able to afford something else, or give it to our children, the values are going to be definitely decreased. And I really don't want to be a name dropper. We all know that Mr. Rogers has a lot to do with this. He's over there all the time with his equipment. Just want to know, but this is what I believe. I wouldn't say it if I didn't feel it.
You cannot name a person on the council.
Well, I take that back. So let's just stay. There's a well-known person in this community
Thank you,
that's
sir.
involved.
Thank you.
Okay? And you people on the planning board, I hope you're not involved in that, or maybe we should all resign and we should get more people. That's what I feel. Thank you.
Thank you.
I just had a concern.
Please stand and state your name and
Lynn
address.
Ryder, Burgess Road. I just had a concern when I got my tax bills this week. I got 4 envelopes. And I know people are telling me, because I can't remember the last year, but I do remember back in the day when you got one envelope with the 4 sheets in there. So rather than 40 cents, it cost $1.60 to send them to my house. That amount quadrupled, and it just, I don't know if it's the new, if there's a new company doing it or whatever, it just seems like a bit of a waste.
Thank you. Sally Freestone. Please state your name and address.
Yes, I'm Sally Freestone, and I live at 48 Mount Hygieia Road. I'm only one citizen of Foster, and yet I'm standing to speak to you because I feel I must. I may be spitting into the wind, but I still will speak. And if you will listen, Mr. Rogers, I'd appreciate it. I need you to know that I am personally...
Be careful.
Oh, sorry, baby. I need you to know that I am appalled by what I think is happening concerning Mr. St. Croix's property. It's not going to be lovely hayfields with horses running free. Both the planning board and the zoning board voted to stop the gravel extraction for myriad reasons. The courts have also recommended that Mr. St. Croix cease and desist his rape of the land, the shattering of our peace, and the destruction of the ecosystems. let it be known that I stand up and speak for the will of the people. We who elected you, the town council members, you swore an oath to listen to us, and you have the power to halt St. Croix's destructive and illegal actions. Please do not act unilaterally. Listen to what we the people want for our town. Please.
Thank you. Dylan Conley? Is it Conley?
Conley, yes.
Thank you, would you state your name and address?
Dylan Conley, 123 Dyer Street, Providence, Rhode Island. I'm here on behalf of the Sparks. I'm here to caution the honorable members of the town council from making an illegal action this evening. I understand that there is a consent order proposed to be entered into. Pursuant to the Rhode Island Zoning Enabling Act, zoning law is underneath the exclusive jurisdiction of the zoning board. The zoning board has its own corporate authority to sue and be sued. This council does not have the ability to overturn a zoning board decision. Only the zoning board can overturn its decisions or enter into settlement agreements. Otherwise, this council would basically be saying that there's no point to the zoning board. You can just be sued and then settle out every single time. So what you have in front of you is a scenario where by entering into this consent agreement, you'll be illegally usurping the jurisdiction of the zoning board. Zoning board, as a separate and distinct corporate capacity, would have the authority to sue this council. So you'd be putting a dividing line in between the zoning board and the town council. The lawsuit would actually be paid for on both sides by the town of Foster. But separate attorneys would have to represent the parties because there'd be a conflict for the solicitor. I would also caution against, as based on a presentation earlier this evening, anyone voting on an action which is a conflict of interest. If you've ever had any financial interest in the site, or if you've ever had any financial interest with the individual, Mr. St. Croix or St. LLC, St. 23 LLC, there will be a conflict of interest to vote in this matter. Given that explanation, I would hope that this council would reject the consent order and act within the confines of its jurisdiction.
Thank you so much.
Thank you.
At this time, I'd like to announce that Ms. Forrest has been excused. She is out of town. We will move on to our warrants. We have payroll warrant number 50. I would entertain a motion.
I make a motion to accept payroll warrant number 50 in the amount of $34,168.55.
Second.
Discussion. Hearing none, all in favor?
Aye.
Opposed? Moving on to payroll warrant number 57.
Make a motion to accept payroll warrant number 57 in the amount of $46,714.26.
Second.
Discussion. Hearing none, all in favor?
Aye.
Opposed? Moving on to general warrant number 24.
Make a motion to accept general warrant number 24 in the amount of $43,900.35.
Second.
Discussion? Hearing none, all in favor?
Aye.
Opposed? Moving on to general warrant number 24A.
Make a motion we pay general warrant 24A in the amount of $316.67.
Second.
Discussion? Hearing none, all in favor?
Aye.
Opposed? And one recusal. Moving on to monthly reports.
Make a motion to accept the monthly report for Building and Zoning Department, Department of Public Works, Human Services, Planning Department, Police Department, Rhode Island Resource Recovery, Tax Assessor.
Second.
Discussion. I do have a couple of things I'd like to note. I noticed that Mr. Bishop has submitted a new format. I really enjoyed this, if you would let him know that.
Oh, sure.
I thought that was much easier. I noticed in the Public Works that the drag box that was purchased several years ago has been put together and used to asphalt the entrance to the townhouse. You'll notice that it's much nicer, and along the back here. So please take note of that. And my last comment is on the Department of Human Services, that there is a new director at RIPTA, who may be willing to revisit the proposal for rural bus route. Oh, Mr. Rogers, I thought you might be interested in that. And also that there are free smoke detector programs for families in Foster. There is no need-based, there's no financial means to purchase one, and they are installed free. And that is courtesy of Aaron Moslin, working with the American Red Cross. Did anybody else have any comments?
I believe they also work on a portion of Shippey Schoolhouse Road with that drive box.
Yes, it seems to be working out very nicely. I'm glad it's out of the box. Moving on. Do we have any other discussion? Hearing none, all in favor?
Aye.
Opposed? Going on to old business, the Cole Med program was brought forward in the past, and Ms. Rush, you were going to attend something that was reflecting this, so would you care to?
We're part, as you know, of a collaborative for healthcare. As part of the federal legislation, all programs that offer health and dental, well, health specifically, have to have some sort of telemedicine portion of their benefits starting July 1st, especially, I don't know if it's everyone, but definitely people who follow or over 50 employees or more. So through the collaborative, they contacted this telemedicine through Blue Cross Blue Shield, and they are offering that as part of the program to all the people who are now part of the collaborative. That's West Greenwich, Foster School, Town of Foster. We had already not known that they were going to do this because we hadn't had a meeting for like 4 months because they were in the middle of RFPs for medical benefits. We looked at the meds program that some other places have, and we were looking into that and actually going to contract and doing that. We do not need 2 plans. This one is 50 cents per employee covered by medical. The other one's $6 per employee. We did hear good things about it. Cranston Schools, who is a member of the collaborative and who was also a member of the meds, they, I guess, brought this up during the meeting that they were gonna, they already have a contract in place, but they're gonna see how it goes. Because you know how he was saying that there's so many savings, and I said, really, how are you quantifying those savings? Because you're assuming that every single person who called here would have sought some other care. I guess there is a way to chart it through this program, so they're gonna see how well everyone does and then determine whether they're gonna continue it. Honestly, at this point, this would be no out-of-pocket cost because it's already going to be built into our premiums. WB Community Health is going to administer it. Blue Cross Blue Shield, which our employees already have, are going to receive it through them. It's an easier transition. It's part of our benefits. So although you had originally said that maybe we should look into the meds, I'm suggesting that you go with this one instead. If that's acceptable to you, you have to let me know by tomorrow.
Thank you for doing the analysis on both of them. Just so for the sake of moving this on the deadline, I'll make a motion. Make a motion to move forward with the American Well telemedicine program through Blue Cross Blue Shield and Arlington Local Trust.
Yeah.
Second.
I heard Mr. Dillon first.
Excuse me, what did you say, Rhode Island Mutual Local Trust? No,
Yeah,
it's
it's
WB Community.
WB, excuse me.
Health.
For W Community.
And I heard Mr. Dillon first. Any further discussion? Mrs. Wright.
Could you explain to us what this is?
We had a gentleman come one night and explain the other program. I'm just
Okay,
saying,
so the
there was another
telemed,
program.
call med, what does that mean? Call
Yes,
Yes.
rather than the doctor's visit?
Yes.
for some items, for some things, not everything, but some things. You've got a sick child in the middle of the night, he's running a tent, this, that, should we go to the hospital, or can we do something else? That type of thing. It's nothing that, appendicitis, you're gonna talk to them on the phone. But it's those things that instead of going into a walk-in clinic, this type of thing.
And this is at the
Participants.
employee's
Right,
discretion whether or
yes.
not they use it?
Yes.
They're not penalized if they don't use it?
Okay. It's at their discretion.
Yeah.
And I know several people who have it through their employees and like it immensely. Thank you, Kelly, for doing that research.
Yes.
You're welcome.
So we've had a motion, it's been seconded, all in favor?
Aye.
Opposed? Moving on to the financial statements and standards, policies, and procedures for non-town entities receiving appropriations. Would it be all right for me to address some of Mr. Peterson's comments now? Under
Well, I
this?
think, we've been, if I could just say a
Sure.
couple of words, we've been over this for numerous council meetings now, and we've done a bunch of research on it, and it's pretty clear under Rhode Island statutory law. I'm going to read you the quote here. Section 4518(2) provides any volunteer fire company or organization may be required to present to the town or city council, whenever receiving any money or approved funds, a detailed statement of its assets and liabilities, and an estimate of the probable current and operating expenses for a given period, any other information about its financial condition that the town or city council may require. The reason why that is done is to give a small town like this that's always under the gun, because the state continues to take money away from small towns, especially rural towns, and gives it to, the cities that are always seem to be having problems because they're not run properly, is the idea that you can request that the fire departments give you a breakdown of what they're spending per year and what they're bringing in. As an example, rescue recovery money. I know this is something that Kelly's been asking for at least since the year and a half that we've been here. So the research shows that you're allowed to do that. And I think it's a matter of good fiscal responsibility in a small town where money is getting tighter and tighter. Other small towns do it. You that know me know that I'm the chair of the West Greenwich Town Council. We require all of our volunteer fire departments, all three of them, to comply with this, and we know exactly what they're bringing in from rescue recovery money. We still give them the same amount of money every year. It's just good policy for your taxpayers to understand what's going on here. It's not a shot at any of the volunteer fire departments, but it's required by state law that you can require that.
Could I read actually what was requested and what most of them are already pre-done?
Yes.
Because it was in the, I
Yes,
understand.
I got it.
It
So,
is.
so basically, this is what it entails, and almost all the fire departments are currently doing almost all of these to begin with, so I don't know where the problem is. But there's the controls that should be included, and then reporting to the town. So basically, the controls that requesting should be done are done in almost any kind of financial reporting, any agency, whether it's just good fiscal procedures. There's A through F. A, a review of all expenditure document. This is what we're asking them to do for their own sake. A review of,
That's in the volunteer departments.
right.
The four departments, thank you.
A review of all expenditure documentation by someone independent of the treasurer or person preparing the payment of financial record reports. Dual signature requirements on checks. And as many of you know, the purpose for that is many times when there's one person signing the checks, you don't really realize anything bad's going on until it's way down the road. So it's checks and balances. C, a review of the bank reconciliations by someone independent of the treasurer or person who reconciles them. This is intended to be quick process. D, a general ledger accounting system in place for use in preparation of financial reports, Quickens or QuickBooks. E, internal audit or independent review of financial statements. F, the state guidelines for record retention should be utilized for documents used to prepare the financial statement, including revenue and expenditure supporting reports, which I think under their 501c they're required to do anyway. So a lot of the things are actually mandatory for their reporting to hold their 501c3. So that's what we're reaffirming what they should be doing in their books. Reporting to the town is the second phase of that, because we're pinched between our fiscal auditor and our treasurer, being forced to make sure we're spending taxpayers' money. We are bound by many ways on the state side to be fiscally responsible. Annual reporting for appropriation should include the following in this file. Most recent IRS Form 990, which would help with the situation with Station 2 not to happen. Balance sheet for organization's most recent fiscal year end. Income statements for organization most recent fiscal year and I just said that one, and a year-to-date budget to actual, and 5, budget for upcoming fiscal year, including all sources of revenues and all anticipated expenditures, which they do when they come for their budgets. So.
They're not providing it actually recently.
Right, so, I've talked to several departments and they say, we're already doing all of that. So, that's what this is about, so you weren't confused on what was being done, what was being asked, so I figured I'd leave that in the record.
Thank you. Okay, now address Mr. Peterson. Mr. Peterson, you brought out some good points. I couldn't address them in your public comment, but I can now. One of them is making the changes in person. I believe I went to the engineering board. I believe Mr. Rogers went to the engineering board, and Ms. Russ went to the engineering board like a year and a half ago and sat with them and talked to them. We've also met with individual chiefs. I know Ms. Russ and I have with, Mr. Stone have met with individual chiefs. But it is a good point. Making it an email is not exactly the way we do it here. The shared liability insurance,
We're paying their insurance, so.
that's one thing I could not understand, Mr. Pearson, when you said that one department, and I didn't write it down, a portion of their budget goes to paying the insurance. I thought we paid insurance under our,
No, we give them a check, and the insurance is quarterly paid, and it's through,
the trust.
They insure together, I believe, all the departments, and they have their own policy through, I think, the Rhode Island Interlocal Trust, and they also have one through VFIS, which also insures us for our IMG claims. So they do it, but I believe that's one of the expenses that they ask us to reimburse them on, because I think they list that insurance on their budget request.
Can you explain that a little further, Mr.
we're also
Pearson?
self-insured for injuries amongst ourselves that we requested from the town. If one of us gets hurt on a call and we're out of work, we have insurance, will cover our bills and give us enough money to continue forward without losing anything.
I wasn't sure about that, Mr. Peterson.
Can anybody speak now? I just.
I'm asking Mr. Peterson a question, so if he could answer, thank you.
I'll give an example of Station 3. Okay.
And for people that don't know, Station 3 is
Gloucester Center.
Right there.
Gloucester Central. Yes, thank you.
Station 3 has a policy for liability with regard to itself. Also, it has a policy with regard to the firefighters themselves if they're injured on the job, etc. Now, there's town liability with regard to the trucks. Now, you can't sue the king, but on the other hand, there's plenty of things in Rhode Island law, as the council knows, that the town is on hook for a good portion of this. And my point was that instead of having things done separately, there ought to be better coordination with regard to liability and protection of these kind of volunteers, because they are placing themselves in some risk for the town. That's the point. That's all.
Okay, and I'm going to ask that you let us look into that further, because I thought we were taking care of that.
We are, basically, like the engineering, like the policy I just explained to you on our injuries, if we get hurt, we were concerned about not being able to pay our bills or our commitments. So, the engineering board got together, got a price, and each divided up into each department. So, for example, some of the things we're asking for is exactly that. When they come to us with their budget and expenditures, they show that insurance policy, like divvied up between the 4 departments, that cost that they came to us and asked for, starting at the engineering board. So that is all covered. They come to the town, and that's part of their income and expense on their reporting. And if they don't report it, we don't know what they're spending the money on.
And that was my understanding, is that we were giving them money towards that.
Yes, yes.
So, okay.
Do you remember a couple of years back too, their insurance policy increased exponentially?
Yeah.
well over $10,000. So each one came in and they said that they needed additional money because the insurance policy increased to cover these very things. And we did in fact fund them the additional money that they requested to pay for this policy.
So, Mr. Peterson, I'm going to look into that further, and we will get documentation to you. But so it's my understanding that that is being done.
Yeah.
I do like your suggestion that we recognize the EMT and the firefighters. That is something that we should do, and thank you for that suggestion. Does anyone else on the council have questions? I know you want to. Anyone else have anything to discuss? Oh,
The only point I wanted to bring up, a member of the fire EMS service for over 38 years and past president of the engineering board. I understand how a lot of this works, so I'm trying to be helpful with some of the things that Mr. Peterson brought up that we already do cover, and it entails in the part of this, and it actually helps them, help us do it and provide those services back to them.
right. Yes, please state your name and
Yeah,
address.
my name is Anna Ilo. I live in Baltimore Central Park. I have a couple of questions to this particular partner which you have. First of all, how many volunteer fire people do you have?
How
And
many-
transportation, persons who work in the fire department and rescue.
I'm not sure I have that information right here.
How many do they
They
have?
are private, their membership goes up and down, and we always have difficulty. Sometimes we have many members, but we have very few members that are active. But they are private entities having their own membership and voting in their own people, and
Oh, okay.
That's nothing to do with the
another
town.
question I have, because each one of those people who drive your trucks, do they get coverage for occupational health if something happens to them?
that's the whole thing that I just explained. We have a
Yeah, okay,
policy,
that's
if I get hurt,
fine.
that's all
Yeah.
covered, and it's paid for by the town. They come to us with a budget, and that's in their budget as a breakdown, as a cost moving forward.
Okay, that's number two. Number three, I have another question concerning this. Not only just the workman's coverage, but also do they collect reimbursement from the people who get transported through their insurance? What happens to that money which they collect from the insurance company?
Okay.
Does the town collect it or who collects it?
They are collecting, it's done very different in this town compared to other towns. For example, the town of Situate on the ambulance calls, the town, they hire a third-party billing company that goes and does this. In the town of Situate, I believe the funds come back into the town and it's used to offset their budget when they come to the town. In the town of Foster, one fire department, I believe, is just starting the third-party bill on certain things. The ambulance corps, for many years, has been doing third-party billing. And just for, and I will give you an example. My son just took a transport ride less than 2 months ago to Rhode Island Hospital. He was billed, and he doesn't have insurance. He is a taxpayer in the town. He was billed $3,200 for that it was $2,200 just for the transport ride and rescue to Rhode Island Hospital.
There was life-saving in rescue. There
No,
were 3 people in the rescue.
No, he had superficial wounds.
How many?
Superficial wounds, not life-threatening at all.
And they charged the insurance, and he had no insurance?
The total,
How
no,
did
the
you
total
get
bill
rid of
came
it?
to, I got it on my desk. The total bill for my son was $3,200. He is over the age of 26, so he does not have the medical anymore. He hasn't transitioned into his own. He is actually 26 or 27, so he's in that period between getting his own.
So that means all those people who we have no account of, who are on the rescue or the fire department, they may get stuck with the same bill.
They will, and what's unfortunate is, some people go and dig in their pockets and pay for it, and I've heard that, we're only gonna send you a bill, you don't have to pay it. But that, to me, I find kind of odd. Some people unknowingly, they may not know that, and they may go into their piggy bank, even though they're paying for the service in their tax dollars, may dish out thousands of dollars, but the other person, I've had people who were told, because when you call, why did I get charged $3,200? I'm not using that as an example. Other people have been told, don't worry about it, don't bother paying it, just ignore it. You don't have insurance. We'll go after the insurance.
Well, I think that's mostly unfair for the people who follow the rules and regulations. I understand that there are some people who actually cannot have it. But young people who are 26 years old, they can get health insurance for $130 a month.
Right. Well, here's another unique part. I'm glad you kind of brought it up, and I'm not picking sides. Listen, I went out the door at 2 o'clock in the morning. On that same example of that ride, you had a driver, an EMT, and a cardiac.
Yeah.
That driver, EMT and Cardiac, you will hear the ambulance corps, the fire department say, that driver only got $15. That EMT only got $17, and that cardiac got $20. That is a tremendous savings for the town of Forest on our tax bill. But if you look at the bill and break it down, those 3 people were charged, the insurance company, well over $1,000.
So who collects
So
that
my
money?
point is, maybe the ambulance corps should be giving them a little bit more than 15, 17, and 20 that they're collecting from the taxpayer.
Is that tonight's topic though?
Well, she's asking questions.
But it's
I'm-
very important for you because that protects you so that you do not get sued. Because I remember one time the town had to pay $1 million to a police person many years ago. That is on record.
Down the
They concerned about the young people, especially like this man said, 3 young men from one department just passed the EMT test and the firefighting test. There are big problems with that. I hope that you consider and check this out. And I do like to know who collects the money when people pay their bills.
Thank you.
Excuse me.
Mr. Savazzi.
Yes, this has been going on for a year. Nobody's special, okay? You're asking them to report they don't have any choice but to report. They're not special. There are no special volunteers. I don't care how hard they work. Other people work hard. So your duty at the town financial meeting was to not give them money or they report. Now your duty is cut them off because they have a responsibility. And this has been going on for a year. When are you going to develop some courage?
Thank you, Mr. Savazzi.
You're welcome.
We did have this on an agenda in the past, and it was asked to be removed or postponed for Mr. Gorham to attend. I do not see Mr. Gorham
No,
here.
because only tonight.
Oh, so he's not here. I just wanted to make sure we didn't miss him. Mrs. Ryder.
I do see an issue where this could be abused. When the solicitor went over the law, there was a lot of the town may. But it wasn't part of the law. The town may ask for this, but the town doesn't necessarily have to ask for this. And I also heard that in West Greenwich, you want to know all of the revenues and everything that they have, but you're going to keep giving them the same amount of money. Well, yay for West Greenwich. That might not happen in another town. They might say, well, look at this station. They've been raising money like crazy. They don't need as much from the town. That I can see is a very slippery slope. And I think that the companies, the ambulance corps and the fire companies have a right to be concerned, and they should not be penalized for making their own money and getting their own money.
It's not about that.
Thank you. I will also state that this has been a future agenda item for
I know.
over 3 years.
Kelly has
4
one.
years. Kelly?
I just want to point out that everybody seems to be concerned about the money that they're raising through fundraising, etc. But that has never been a consideration in the 10 years that I've been here, the money that they're raising. It is a valid question to ask how much you have received in billings and how much have you recognized in billings when you are asking the town for a significant amount of money. And in some cases, you're saying we don't have enough money, or we're going to have an additional $10,000 expense this year. Can you fund it? It's a lot to ask a body of people to fund something when you have absolutely no idea how much money they have raised, not through contributions or fundraising and their own efforts, but through billings, through interest, through whatever clause that you have. When they are now refusing to supply any information that 3 to 4 years ago they voluntarily supplied. This was just a matter of putting down and writing basic procedures that most of them had already followed. And now all of a sudden, they're digging heels in a way that I just think is unnecessary and quite frankly, somewhat alarming in the way that they're fighting so hard to not report or to not have any internal controls. As a town council who's responsible for your money, when you were giving out $300,000 to volunteer organizations, they're not treating the volunteers unfairly, in my opinion. They're simply asking for some correspondence. How much money have you billed last year? What were your actual expenditures? How much did you actually collect? I know you budgeted, say you budgeted $100,000 to bill, and the town paid for the difference. If you actually collected $150,000, do you think the town is not eligible or should not be responsible or allowed to know that you collected 150 when you only budgeted 100? And I'm not saying that they're going to do anything with the information, it's informational only, that's one thing. The second thing is basic internal controls. If you're gonna collect $100,000 or $90,000, they are asking that you have procedures in place to account for that $100,000. It shouldn't be a pen and paper, it shouldn't be an Excel spreadsheet, it should be a program such as Quicken or QuickBooks or whatever you wanna use to account for that money, so that you can actually get a button and present a financial statement. What they're asking for here in financial statements, if you have a program, is literally 15 minutes. It's the press of a button to you, an income statement and a balance sheet for your organization. Most of these communities did this. The reason that for the 990 is because, as anybody who's watched, the council meetings for years, we've had problems with a tax exempt organization losing their tax exempt status because they did not file a 990. This went on for years. It became a huge problem for us because now, as you know, they own the buildings. We are not taxing those buildings because they are tax exempt organizations. When they lose that tax exempt status and we are no longer taxing that building, that becomes a responsibility for us. So they have a responsibility to track this information, to monitor it, they're not criticizing them, they are not withholding funds, they haven't done any of that. They're just asking them for their own purposes to say, please indicate to us that you have internal controls and procedures that you follow so that we have a certain assurance. We have to do the same thing for the federal and state government. Whenever we take their money, we have to fill out forms assuring them that we will comply with certain internal controls. We're asking them to do the same. And then a certain reporting requirement, that's it. That's all they're asking.
I can hear some, because we had talking, thank you, it's hard to hear up here. Thank you, Kelly. Could you state your name and address, please?
Lori Cudjoe, Cecile Daniels. I'm maybe a little confused, but I don't get a volunteer system, not a pay-by-call system.
I'm sorry, I couldn't.
Mr. Rogers just stated that they get paid X amount of dollars per call. But I thought we were a volunteer system.
They are a volunteer. I'm not sure, do all the
The
fire,
ambulance,
the ambulance
the
corps.
ambulance corps.
The
So
ambulance corps
our
gets
system
the
is not
same.
all volunteer. Our ambulance corps is a paid-by-call system.
They don't get much, they get 17, 15, and 20, it's absolutely minimal, and that's what they
That's
requested.
not minimal
They-
when I've volunteered my time for over 20 years.
Understood.
In the department.
Understood.
So that's what I'm questioning. We don't have a full volunteer system, just like Hope Jackson. They have volunteer systems, but Hope Jackson's paid by call. You get paid per call, and you get a monthly check. So does anybody know how much is actually being paid out for the calls?
Those stipends have been the same for the last almost 20 years, 15 to 20 years.
It has not, because I've been in this town over 20 years.
38 years, I was involved when they actually brought that in. They first tried to do a tax rebate abatement for volunteers, and they moved to it. They had a meeting at Station 2, and it was implemented about 15 or 20 years ago. The dollar amount was probably around 10, 12, and 14. It's gone up minimal since then. It's the ambulance corps, but then they will turn around and third-party bill $800 or $900 for that same crew through the insurance company.
Yes.
But they're not giving them any of that money. They're only
As
giving
far
it to
as I
the
was told through the ambulance corps some 15, 16 years ago, that if I had insurance, that they would bill my health insurance, but not bill me directly. That's how the ambulance corps was run.
The bill comes to the house.
A bill does come to the house, and when you call them, they will tell you that they will bill your insurance company if you have insurance, and then don't worry about the balance. And personally, it would have been cheaper to call a private ambulance, because that's a ridiculous amount.
Thank you. Mrs. Ryder.
It just seems that if they are suddenly digging in their heels, not wanting to do what they've been doing all along, there is a bigger problem, and the question needs to be asked, why all of a sudden? There seems be a decided lack of communication, lack of trust, lack of something, for them to do this.
We could get more
We
cards.
requested them to be here,
Kelly,
all the chiefs or a representative.
In all of our correspondence, every single time I've addressed it with a particular chief for each of the departments, the chief never has a problem with it. They mostly agree, they say whatever, but when you get them together as a group, for whatever reason, there's somebody holding back, and as a group, they don't want to take a stand. But when you speak to each individual, you were with me,
I know.
they agreed. I've spoken to, 1, 2, 3, who's the fourth? 4 different people from all different departments, and honestly, when you speak to them individually, they agree that there's nothing actually really wrong. We're not asking for anything out of control. There was one thing that they thought was a little bit over the top, so we removed it. It was quarterly something or other. We removed it. So I don't know why they refused to get together as a group. I don't know why they refused to sign so that we have something in writing that says that they will have internal control, so in case something ever happens, they can say they did their due diligence, they followed up and verified that they have systems in place. I don't understand it. I really don't.
Do they have a log about transportation, how many they do a week? Because there's a lot of traffic on Route 6, many accidents.
We do get reports.
So maybe
of
they
it.
have to,
We do get reports, what Mr. Peterson was
the
talking about. is
log,
quarterly.
the logs.
Yes.
So they do keep track of the transportation they do per day or per month.
We do get quarterly reports, which Mr. Peterson had mentioned, and it does tell us how many runs they made.
Okay,
If that's
so
what you're
you
asking.
just count how many they make per month, because you're still liable for all this runs. If there something happens with patients who are in that truck, and if they want to collect
Well, we
something
can't
afterwards.
really get, there's this HIPAA law, we really can't get into that.
No, you don't need to have the name. All you need to know is how many runs they
they
made.
do.
They do
They
tell
don't
us that.
tell us that.
They tell us
They
that.
tell us that.
Okay, so we can keep track of that. Somebody keeps track of that.
Every single call that's gone.
Because I'm really concerned about those young people who are not even 18 years old who are now involved in that. I don't even know how many.
I'm not sure that under 18 are on the rescue tending to people.
No.
They are not under 18 tending to people.
They're in the fire
They
department.
have, right.
Well, that's even
Fire.
worse if they go to.
They're in the
a
fire, not the, okay.
So I did want to say, like, this letter, whoever said that there was lack of communication, this email went out. This was not the first time that they've seen this. They saw this, what, like a year ago,
Yeah.
over a year ago. Then we met with them. I was at an engineering board meeting where Gordon attended, and I asked them any questions. I went over it in detail, pretty much identical, like exactly like this. And they said that they were going to look at it and get back to us. Then I met with a particular chief. He said that he was on board. He actually felt like they should be audited, like not even just independent, like, not even just internally, that he would welcome an external audit. But I didn't know if that was necessary or how we would fund it. I said that's something for discussion. And he was gonna go back to his board and let us know within a few weeks. Never heard from him again. Then, June 1st, we sent this out to ask that it go on a meeting. We reiterated the notice, and we put it on the next agenda. They said that someone couldn't attend, so if we could postpone it. We've now postponed it again, and then I'm here. I honestly don't know what the problem is. I don't know where you're going to go from here.
I just want to add one final thing. I mean, I've said it, I am a volunteer in this town. I would never not support my volunteers. There's the guys that I run in fires and I get up and I cut people out of cars in the middle of the night with. I know for a fact that I would never sell them down the river, and I have never seen this council ever go against the backbone of these volunteers. That's a false narrative being spread, because I wouldn't allow it here. I understand what you're saying, but we are not anti-volunteer. I will tell you that from the bottom of my heart. And most of you people out there know that, because you've seen me at all times of the hour in the middle of the night, helping you out.
I'm not against volunteering, believe me, but I'm against not protecting the volunteers. And that is a big
I think
problem.
that this might be a conversation that you have privately with one of the ambulance corps. Okay?
Oh, no, how much, is their budget? 300,000 for three?
Motion move the question at this point.
Thank you.
Yeah, okay, you can move it.
We have to move on.
Just, you want to implement that, what Kelly would like, you can vote on that. And again,
Okay.
require the departments to comply with that.
I make a motion at this time to request that this council move forward in implementing the requirements that I read for the record into the town. We've had extensive conversation with them, and we don't have to rehash the whole thing. So I make a motion that we move forward in implementing that.
Second.
The motion has been made and seconded. We've been asked to move the question, so there'll be no further discussion. All in favor?
Aye.
Aye.
Opposed? It moves. Moving on to the Police Department Town Hall Communications Technology. Chief, you were going to, actually you gave us something.
Yes, prior to the meeting, Al Costa and Kelly have been in communication, trying to save the town some money by bettering the computer system. It's going to be huge savings. Al Costa has already investigated the police department. The next step is the town computers, and he's coordinating that with Kelly.
Okay. So we have some information in front of us. Can you explain, is this the,
I just want that stuff and I didn't really have.
Oh, okay. Is this from you, Chief, or is this from you?
I forwarded it to the chief. That's the backup cost, as opposed to what you pay now currently, and also the antivirus that we require for the network as well as the endpoints, the PC and the station. So, and adding that second figure, the antivirus, compared to what you pay for a backup of data for the police department on a yearly basis, that still saves you about $2,600 a year.
So what we're doing is we're looking into the town next to see what a combined savings would be by changing the way we back up our systems. To see if we can save some money so that we can possibly hire, in this case it would be him, to help us maintain our computers daily and weekly. So that, because there's so many things that pop up that one person's having a problem with their computer, we just don't have anybody in-house. So that they could maybe work 5 to 8 hours a week, depending on what the needs were, if we can free up enough money by just changing the way we're doing it.
So would it be beneficial to wait till he's completed the town hall portion of it
I believe.
before we go? Great, so we do not need to make any motion tonight.
Just a future agenda item.
A future agenda item, thank you. Moving on. New business, July and August town council meeting schedule. In the past, we have brought this forward, we have 2 meetings in July and 2 meetings in August.
It's the whole home day kind of gets
Right.
close to one of them, and it's
So I'm looking at my calendar, we would have a meeting on the 12th and then on the 26th, which is Old Homes Day weekend. So, for July.
That's when they drop them off your house.
I'm sorry.
That's getting dropped off.
Yes, we're aware of that, thank you. What is the pleasure of the council?
The first date?
The first date is the 12th, and the second day is the 26th, which is the day before Old Home Day.
I don't mind doing twice a month.
We knew that.
It's my life.
So meet the 12th.
So we have a motion to meet on July 12th only?
Yeah.
So now, looking forward to August, we would be meeting on August 9th and August 23rd. Or do we want to move August to July's meeting to decide then?
I think you can have one in each month, and if there is something
That needs
of needs, we can have
And
it.
that's,
We
right, that's
can
what we've
have a
done in the
special-
past.
Special meeting,
We have done in the past.
meet the requirements for reporting and at home.
So far, we have a motion to have a meeting on July 12th. And would you follow through with August 9th?
And August 9th.
And then if we need, we can hold a meeting on the 26th or the 23rd. Am I,
If need be.
is that your motion?
That's it.
Okay, thank you. Do I have a second?
Sorry.
Thank you. Any further discussion?
All the people be notified?
We posted on the Secretary of State's website. Any further discussion? Hearing none, all in favor?
Aye.
Opposed?
No.
We expect that.
What's that?
It's 3-1.
Yeah.
Okay, so then we have next a proclamation for, as Mr. Peterson mentioned, it's for Sharon Carter.
Can you read it?
I hope she doesn't see it.
All right. She's not here, is she?
No, she's not, but you're there.
All right. Whereas Sharon Carter joined the Forest Ambulance Corps in 1991 and volunteered her time and services as has been the tradition and continues to be an elemental part of the essence and tradition of our country and essential to the spirit and vitality. And whereas Sharon Carter became commander in 2004 and was dedicated to serving the residents of town of Forster, and whereas it is ever more evidence that our community's greatest resource is its people, and whereas the residents of Forster and many town organizations benefit from Sharon Carter's enthusiastic sharing of her skills, talents throughout the years and by serving this community, and whereas the townspeople of Forster wish to show appreciation and recognition to Sharon Carter, who serves with dedication at the expense of her own and her family's time, and whereas it is fitting to set aside a special day to tribute to dedicated citizens such as Sharon Carter who work to improve the quality of life in our community and make it a special place in which to live, work, and recreate. Now therefore, the Forster Town Council of the Town of Forster hereby proclaims July 9th, 2018 to be Sharon Carter Appreciation Day, and hereby encourages all residents to recognize and honor and support Sharon Carter for serving our community. Dated this 28th day of June 2018. And with that, I make a motion to move this proclamation forward.
Second.
Any discussion?
I've had the opportunity to work with Sharon since she started on the ambulance squad. I was actually a lieutenant under her leadership, and there is nobody finer that will commit her entire life and dedication and work to the town and not ask for a penny. So
That's for sure.
I've had
She's
many
also our assistant EMA director. She,
former citizen of the year,
Mhm.
greatly so. But yep, there's not that many that
No.
shine around.
No, that's for sure. It's been, a motion's been made, it's been seconded. Any further discussion? Hearing none, all in favor?
Aye.
Opposed? Thank you. I will let you know that this will be presented to Sharon on July 9th. Can I ask you to hang on to this? Thank you. Moving on, the town of Forster versus St. Croix decision.
If I may, could I start?
Thank you.
Basically, this is an action that's been brought in Superior Court. I know Mr. Conley's been at the hearings with an associate from my office, the Assistant Solicitor Joanna Achille, along with John Mancini, and an associate at his office.
Could you speak up?
Sure. So, it's been in court, in Superior Court. The judge had asked if the sides could get together to try to come to some type of an agreement before she made a decision. The judge was, Mr. Conley will know better than I, he was there, but what Ms. Achille tells me was vacillating back and forth between whether or not it was a right to farm issue, or whether or not the town could keep the injunction and the cease and desist in effect, or move in effect with that, and she would uphold it. When you get that from a judge that says that, you better if you all would go outside the courtroom or in the next week, try to work out some type of a compromise that neither side is going to like, but it's better than her making the decision. It was Judge Kehoe in this particular instance. And in that particular week, Mr. St. Croix's attorneys in our office, on behalf of the town of Forster, entered into an agreement. which is been codified in a consent agreement that the council has in front of them tonight. So that was, and I think Mr. Rogers wants to read, when I get done, read what happened that day in court. It's my opinion, and I respectfully disagree with Mr. Conley, is the town council is the elected board in town. They're the proverbial buck stops there, as President Truman said. The zoning board is a board that's appointed by the town council, and by your town charter, it has an advisory opinion to the town council. Anytime there is litigation, it is our opinion that the town council is the ultimate arbiter of what happens in this town, because they are dealing with your taxpayer money. The boards don't deal with that. It's your elected officials handle all matters that deal with finances. They have the ultimate say. In this particular case, once litigation was put forth first by Mr. Conley's client, and then we joined our own, filed our own suit against Mr. St. Croix, that then moved it to the town council to make the ultimate decision. It went back and forth. It was our opinion and our opinion to the council that this was not going to end either way in court on those 2 Fridays. Whoever did not prevail in front of Judge Steele was going to take an appeal to the Supreme Court. It would have been us or Mr. St. Croix. And at that point, the Supreme Court then would have made a decision to send it back down, or whatever. They may have upheld what the judge indicated in her decision and what that may have been. When Mr. Rogers reads the decision, you can tell that the judge indicates that she felt that when Mr. St. Croix came forward and him and his attorney, or his attorney under oath, his attorney as legal counsel for Mr. St. Croix indicated that they were going to put a horse farm in, she had to take that at face value. You can't take and look at what may or may not occur down the road. Once that was the case, and they indicated that they were going to make fields and all this other, kumbaya stuff in front of the judge that day, she took that to mean that that was okay under the Right to Farm Act. That was her opinion. If we got another judge, it could have been another opinion. But that's what she had indicated, that she felt that that was enough, that he met that burden. It's a low burden, but that he met that burden. That was our main concern. So our office indicated to the town is that we had asked the council if we could enter into basically some type of, at the judge's request, some type of negotiations to see if we could come to in a negotiated agreement with Mr. St. Croix and his legal counsel, because we knew that going forward, which was going to cost thousands and thousands of dollars to defend this case, taxpayer dollars. So that is just a little Cliff Note version of what has transpired the last couple of weeks regarding Mr. St. Croix.
And before you read Gordon, I just want to mention that this is on the agenda because we know that there's been a lot of talk out there, and we wanted it to be out there with what was transcribed. So that being said, Gordon, would you read, Mr. One other thing, with the facts, and one other thing, Gordon was not here the night of the decision, so that he was not present during that decision.
I had a prior commitment in Situate to announce something. I've been on the agenda for almost a month for that. So hope you guys have your popcorn ready, because this is actually the discussions between the town lawyer, the St. Croix, 2 lawyers, and Mr. Conley, who was representing the spots. And I'll start, and it was on June 15, 2018. The court judge, when I say the court, I'm pertaining to the judge. When I say Mr. Conley, that's pertaining to the Sparks attorney. And when I say Achille, that is the town solicitor. And when I mention Mancini or Goodyear, that is St. Croix attorney. So, the court. Welcome back, everyone. We were here on originally. There were 2 separate matters that had been filed. Separate, but yet related. I had first and foremost Richard and Kathleen Sparks versus St. 23 LLC and Brian St. Croix, and then the town of Forster. And then after that, the town are forced to file their own motion, or should I say, suit against St. 23 LLC and Ryan St. Croix. Both matters really involve a request by the parties for injunctive relief as it is related to Mr. St. Croix and what he is doing with his property, located on Mount Hager Road in Forest, Rhode Island. I had told the two parties last time that we had some spirited arguments, certainly educational for the court concerning the matter. And that was really what Mr. St. Croix was doing with his property. I heard the arguments from both sides. I was entirely sympathetic to the town and the Sparks concerning their valid and well-placed concerns about Mr. St. Croix, what Mr. St. Croix was doing with his property. That was based primarily on a history of prior applications and things he had done before. But my concern was given Mr. St. Croix's recent statements, or as I think I described it, more of a pivot than that, rather than using his property to run a gravel excavation and mining operation, he intended to use it for a horse farm. That Mr. St. Croix may have found a valid and permissible, more importantly, use for the property. I had suggested at the time that the parties get together and speak, because if Mr. St. Croix was going to operate a horse farm, in my review of the sum of the case law, that may be something he is entitled to do. And it may be in everyone's best interest for the town to take this opportunity to negotiate with Mr. St. Croix and his counsel concerning how that was going to be done. Restrictions that were going to be put in place and steps that could be taken to ensure the town, as well as the Sparks, to a certain degree, that this wasn't a ruse, for lack of a better term, that he still planned on excavating and mining gravelation. He was just going to call it something else. I had an opportunity to speak very briefly this morning with the attorney representing the town of Forster, as well as counsel to Mr. St. Croix, St. 23 LLC. And I understand an agreement of sorts, and I say that because I appreciate that both sides had to give or to agree to things they didn't necessarily want to do. But that, I suppose, the substance of any valid agreement, neither party walks away with everything they want, such that they have this agreement put in place and it has taken the form of a consent judgment. I did have the opportunity to review that, but counsel, why don't you go ahead, and then I will get into the Sparks in a moment. We'll take care of this first. As I understand it, you're still pressing for motion, which is fine, or request. And we'll deal with that in a minute. But I can knock off, well, do that and we'll go from there. Counsel, go ahead. Mr. Killy, that's the town solicitor. Good afternoon, thank you, Your Honor. As you indicated per instruction, the town did sit down with Mr. St. Croix and his attorneys, and we were able to work out an agreement that does satisfy the town council that Mr. St. Croix is going to be operating a horse farm, and that this excavating is going to be an incidental use to the operation of a horse farm. The consent order will allow Mr. St. Croix to excavate the property prior to the commencement of the horse farm in a fashion consistent with DEM permits, and also a site plan that is attached as Exhibit A. This will, essentially, the project will be happening in 4 phases. Each phase is limited to 10 acres, so it will hopefully, the town thought, and I think Mr. St. Croix's thought, is that would limit the noise that is coming off the property in an attempt to condense the operation. In addition, there will be only 60 trucks coming off the property Monday through Friday, so no trucks will be entering and exiting Saturday or Sunday, and he will be able to do some actual excavating and site work during Saturday, but never on Sunday. The town also conceded that if he does need to crush some of the boulders because of their size, he will be able to do that. However, if he's going to be crushing, he will contact the building official, and there will be, Mr. St. Croix, or the corporation, at their expense, will hire professional engineers to take some decibel readings, and we will put some decibel limitations in there to make sure that we're protecting the neighbors' abutting properties from sound. In addition, he will be posting a bond with respect to the soil and erosion, things of that nature, and the work is to be completed within 24 months of today's date, provided that Your Honor signs the consent judgment. 6 months thereafter, he will commence the horse farm, and we've defined a horse farm so that nobody has any questions as to what a horse farm is. The horse farm will have the capacity to stable at least 15 horses, but he will have at least 1/3 occupied, because you never know if people's bringing horses, leaving horses, and things of that nature. And importantly for the town, there are ramifications that will be added to this. The town building official will have open access to the property to make sure that Mr. St. Croix and the companies are complying with the judgment. And if they are not, a notice, council will go ahead, a notice, page 6, will be issued, and that he is in violation of the judgment, and he is to stop all work until there will be an agreement reached. If Mr. St. Croix does not heed to the building official's instructions, the town is required to come to court and get a preliminary injunction. Mr. St. Croix will be responsible for the town's legal fees. In addition, the court, will you do me a quick favor? This is the judge. I apologize only because it's been a real long morning already. Can just, like Mrs. Achilles, slow down. The judge, the court, slow down a little bit. I know I get it. I totally imagine my poor stenographer, if it sounds fast to me, but it's not going to kill her, so if you could please slow down a little bit. Mrs. Achilles. It's not the first time. Yes, that's fine, the court. Achilles again. And lastly, I think the most important thing to the town is if this horse farm is not established within 6 months, following the 24 months of site work, the town will be able to impose a fine of $100 per day, which will be retroactive to December 13th, 2017. So essentially, it's $36,000 a year, and Mr. St. Croix has already assented to that fine. He has essentially assented to a lien being placed on his property to ensure payment of that fine, and he has also agreed if there is any money remaining from the bond posted for the soil sediment erosion, that will also go towards that fine. So the town does feel that there are adequate parameters placed in this incidental project that the town is protected from Mr. St. Croix not complying with the terms of the judgment. Now the judge. Okay, I also saw, because I did go through it, that part of this is that Mr. St. Croix and his company waived any right of appeal. Ms. Achilles, yes, the court. To this court, in conjunction with actions taken by the town of Forster zoning pertaining to the special use permit application advanced by the same parties concerning the property in exchange for the town who is waiving the right to enforce the notice of violation that had previously been entered, correct? Ms. Achilles, yes, Your Honor, the court. Okay, I say that for that reason because there's a couple of other things that I want to put on the record. As I understand it from conference this morning, that not everyone in the town of Forster is happy with this. As I understand it, I truly do sometimes. I think that's a hallmark of a good agreement that everyone walks away unhappy. But there's some more reasons why. I'm inclined to think that this is in the best interest of the town, and I will expound upon that in a second. But to the extent that defense counsel needs to place anything on the record, I wanted to give them an opportunity to do so. Ms. Achilles, I also want to mention, court, sure, Mrs. Achilles. On page 4 of the order that we submitted this morning, we had gone back and forth with drafts, but there is a typo. First paragraph, 4th line. It should say section M. So we will just retype it and bring it in for a signature, but that was it, the court. Okay, Mr. Mancini, who is a lawyer for St. Croix. Mr. Mancini, thank you, Your Honor. John Mancini on behalf of the defendants. Your Honor, this proposed consent judgment really is a good example of a tug of war. The parties did negotiate in good faith, and I can say on behalf of the defendant, we believe that we have waived some of the significant rights. Most importantly, as the court has just noted, it is our appellate rights that have been waived. We've agreed to certain penalties and consequences in the event that this order is not followed. And importantly, this would no longer be a matter of subject to zoning, but in fact, it would be a matter subject to this court review as contempt of court order, which is much different, as the court knows, and the avenue redress for the town is much more direct. With that, we are in agreement with the order. We concur with the synopsis provided by the solicitor, and we're ready to answer any questions, Your Honor. The court, thank you. As the court says, let me ask you this, Mr. Conley, that would be the solicitor, the lawyer for the Sparks. Have you had a chance to look at this? Are you familiar, or do you know what's in the order? Mr. Conley, I was given a copy of the order an hour ago. The court, okay. Mr. Conley, I have reviewed it. The right that Mr. St. Croix is giving up, they make this identical to his proposal to run a mine 2 years ago. I also think that the town council cannot circumvent the authority and jurisdiction of the zoning board. The zoning board has control over zoning use matters. They have difference of opinions with the zoning board, can't then enter into a consent agreement as an end around to the zoning code of the town of Forest. This effectively allows Mr. St. Croix to violate the zoning ordinance by the authority of the town. Okay. Council, despite the fact that the zoning board has already ruled on this and said it is impermissible use, to say that to complete their entire mining operation exactly as proposed in a 2-year period, exactly as originally proposed, and then 6 months later, we'll put 5 horses on a property and, well, sort of, the standards set forth, North Kingston versus Albert, where the Supreme Court found that the retention pond was a necessary and incidental use towards the operation of the turf pond. Critically, in that case, they actually found that the Alberts maintained that the Alberts in that case would be the plaintiff the defendant comparable to St. Croix. They never intended to turn the pond project into a sand and gravel operation. So in that case, you have a temporary retention pond built out to support a farm. In this case, you have a 2-year, in this case, the town, you have a 2-year, 850,000 cubic yard mining operation that is going to be squeezed under the right to farm act by putting 5 horses on it in 6 months after they're done. I don't think the town council has the authority to enter into that agreement. And I think it's a violation of the right to farm act and the rights and the interests of both the parties in the town of Forest, the zoning board, quite frankly. The court, the judge. My concern is because, quite frankly, if I approve this, that certainly implicates the injunctive relief that you are seeking. So that's why I welcome your comments, and that's why I wanted to invite you to do this. As I indicated last time, and let me be very clear on the record, the skepticism, maybe that's a nice word that is expressed by you on behalf of your clients as well as the zoning board, is incredibly well placed. I too think if I was sitting there, I would be that skeptical given the history and the travel. You know, I went through it extensively last time. I looked at the report that was submitted in support of the application for relief from the zoning ordinance special use permit. There is no question that Mr. St. Croix originally proposed was a gravel and mining excavation project. There is no question about this in my mind, and that's why it was denied. I see that, but as I pointed out last time, my concern is this, that there are, best case scenario, he went back, reevaluated his business plan. Worst case scenario is he found a creative way to get what he wants, as what you just said. Don't have to like it, don't have to agree with it. I can't say though, from my review and specifically I'm looking at, I have it right in front of me, the case you just cited, the town versus North Kingston. It's really a very long day, and that's at 767A2, he states it. He may have found exactly as you described, a loophole to the squeeze through. Okay, in my thoughts, when I suggested everyone go back last time and see if they couldn't sit down, was to have something put in place that would keep him honest, for lack of a better term, because if this is a ruse and he's just calling it a different name, he has no intentions of actually running a horse farm, which from everything I have read, would be permitted use of this property, right, with a question mark. Mr. Connolly responds back, we do not dispute that a horse farm would be a permitted use. The court, right. That if this is, in fact, a ruse on his behalf, it seemed to me having a judgment place in allowing the town to get ahead of it, for the lack of a better term, and institute some very specific requirements as to this was going to be done, it would be in the party's best interest. In looking at this consent judgment, the limitation on time sounds, on the time and sounds, what the town's going to be able to do as far as inspecting the resources they have, if he chooses to, and he has, let's be clear, Mr. St. Croix has flagrantly, disregarded any violated prior orders. He's gone ahead and did what he wants to do. There are some repercussions, enforceable ones, if he does that. It seemed to me that the best course of action, although I know nobody wants it, was to at least get out ahead. If he's going to be, rather than spend all the money, time, oh God, years in the courthouse, whatever it be, or up here on the 7th floor on the appeals, let's see if we can put some safeguards in place right now. I've looked at the consent judgment. I get why there's people who don't want this at all. It's not perfect, but it takes some of the uncertainty out of it with respect to that. If he's going to be running a horse farm, and we agree that that's a permitted use, you also agree with me that he's allowed to do. If that's what he's going to do, to make some improvements or altercations to the land so we can run that business. Mr. Connolly responds back. The scale of the improvements need to be so it's necessary for the primary purpose. The primary purpose, the statute itself, 223-4A, describes that it's for the protection of agricultural operations as a primary purpose. 5 horses, 6 months after you're done mining, does not qualify as the primary purpose. The primary purpose. The court, I thought it was 15 horses. Mr. Connolly, the stable will have space for 15. He's only guaranteeing 4 horses on the premises, so you essentially need to build a 3-car garage and only put 1 car on it. The issue is that for 2 years at a minimum, the primary purpose is a mine. That's not agricultural, it's not a site prep. They're providing no documentation saying that this site needs this sort of preparation to support 5 horses. If it's used as a horse farm, it's used to be a horse farm historically. Why can't it be a horse farm as its present state? In the Albert case, the irrigation was a necessary component to the turf farm. Excavating 850,000 cubic yards of gravel is an unnecessary step towards having 5 horses on 125 acres. He could have 5 horses now. The court. Mr. Massini, do you want to respond? And that's the St. Croix of it. I do. The court. To that portion of it, that, Mr. Mancini, I do, Your Honor, I do, Your Honor, I understand the issue. When you look at the order made an attempt to define the farm, and the attempt was to establish a maximum and a minimum. There's 15 horses or stables for 15 horses. The occupancy was only a third, it's 5. But what is being missed and what's not being described specifically is the fact that in conjunction with the horse farm, there is acreage and acres of fields, hay fields, and they are identified on the plan. And the order specifically indicates that the process to be done methodically over a course of 10 acres at a time, so until it's completed and it's identified in its scope of work in the area to work on the plan attached to the order, so that the town and the applicant both understand and know what are the confines in the areas in which the work is to be performed and for what reason. And the reason for this creation of leveling and the topography so as to permit a uniformly to provide grazing, to provide pasturing, and to provide hay fields. That is the conjunction with the horse farm. So the primary purpose is not only essentially housing horses, so we're not just building a 3-car garage for horses, we're building a stable, a riding arena, which is there. It's just getting revamped and then the fields around it. That is truly the essence of a farm, and that's specifically memorialized in the order. And the town went one step further by attaching the exhibit, which is in the plan, which is what we are tied to do, the court. Okay. Mr. Mancini. And one point I'd like to add, also, the soil erosion is also specifically done on that plan, and the creation of the detention basins, converse with the fact pattern in the town versus North Kingston versus Albert. Creation of the hayfield is a result of the Rhode Island DES permit from DEM, which provides for the grading and uniformity of the land, and then the protection of the land by way of creating sheet flow that is appropriate, and that's the purpose of those detention basins. The court. I just wanted him to respond to that one question, but I didn't want to cut you off completely. Ms. Achilles, that's the town solicitor. May I just quickly, as far as the number of horses, I think the town and Mr. St. Croix had to strike a balance because there is a very hefty penalty associated with how many horses are going to be on this farm in the 6 months, or within the 6 months following the site period. The town really wanted to define a horse farm so that it wasn't left open and there would be only one horse. But Mr. St. Croix did have some concerns in that he could have 20 people, 30 people sign up to a stable of horses, and at the last minute back out. And now suddenly he's on the hook for $70,000 to the town. So we attempted to say this is going to be a facility that will hold at least 15 horses, if not more. You will be, within 6 months, at least have a third full. So some of that was a balance because there was a very hefty fine associated with it, the court. Okay, thank you. Sorry, Mr. Conley. Sorry, Mr. Conley, this is the judge. I just wanted to have a response to the portion of it, which I think is a legitimate argument. The scope of the operation isn't commensurate with what they're asking for, but having that response, feel free to respond to that. Here's where Mr. Conley responds. Sure, I really think in order for this to be permissible under the Right to Farm Act, we need affirmative finding that the primary purpose of the property is a horse farm, and that the 850,000 cubic yards, 60 truck per day operation is necessary and commensurate to the operation of a horse farm. Those are the standards set forth in Albert. The excavation was found to be temporary, incidental, and essential for the primary purpose. None of those are the case here. And not to beat a dead horse, good one, but the court, nicely done, the judge says. I like a good pun on a Friday afternoon. Mr. Conley responds back. In the Albert case, the court significantly found that the Alberts did not want to be and were not in the sand and gravel business. In this case, this is 100% clear that the primary purpose in the sand and gravel is in the sand and gravel business. They just think they can put a couple of horses in the back end of it, and that's the back door toilets. Another pun for this afternoon. I think we're putting the cart before the horse. The court, 2 in 1 day. You earned your fee. I think that gets back to, I appreciate it, you're right. I think I said it the last time. Perhaps not well enough. Frustrating, yes. But I'm reading this, and I think a certain assurance has been garnered to make sure that he is doing what he says he's going to do. Does that mean he gets to a certain degree, excavate some gravel, which is what he's wanted to do to begin with? Yes. But I don't think it's that incidental or collateral benefit, if you will, is enough to say that he can't fix up his property to run it as a horse farm. I really do mean it when I say I am wholly sympathetic to not only the immediate neighbors, but the residents of the town, and particularly the zoning board, who has enacted certain ordinances to preserve the land and the community as it is now, and that they've made it abundantly clear that they do not want a gravel mining operation. I wouldn't if I was living there either, without question. I just think, though, he has found a permissible use that allows him, in addition to some of the mining excavation, he may have found a legitimate way to accomplish both items. That was my biggest concern, that he was going to get there anyway. So let's do it while there's some safeguards in place. I am not an expert in any of this. I don't pretend to be. The court is persuaded to a degree, though, that the people who usually are, that being DEM, have issued and approved a number of permits that would allow for this type of work. And because I know when we're first here, Mr. Conley, one of my concerns with respect to the injunctive relief, as far as this early stage, was, well, what's the harm? There was an idea there was an idea of and you can all correct me if I'm wrong, but there being some kind of disturbance with respect to well water. Dust in the air could be bothersome. Those things seem to have been addressed. It also seems as though, and I appreciate you said that there are these zoning ordinances out there, but if what he's doing it is running a horse farm, having hay fields and meadows finding other permissible agricultural uses for this property, I don't know that this court can right now issue, or should I suppose I can do whatever I want, but should issue an injunction. I think that this was a hard-fought compromise between the parties. I think that there is a certain safeguards in here to make sure that Mr. St. Croix is staying honest. There's limitations on it, because I went back as well, Mr. Connolly, to look at the original complaint, and I know you have nuisance complaints in there. Intentionally infliction of emotional distress, negligent claims with respect to the enforcement of the notice of violation in the gravel bank. As I said, there's nuisance claims that are in there. All of that is fine, and that might ultimately resolve itself. The only thing that is in front of me was the request for the injunction relief right now. Mr. Connolly agreed, saying yes. The court responds back. I'm looking at it. It says that you wanted the court to issue a temporary restraining order and/or injunction against the defendants preventing the operation of a gravel bank at the Mount Hygias property. From the looks of this, they have scaled back the operation, for the lack of a better term, that was originally going on. And that's what's being done is a means to get the property into a workable state to have the farm. A lot of this facts here had to do with the fact that it was really a gravel extraction operation that was going on. In here, we seem to have some assurances that that is not the primary purpose and that there's some teeth in it. I want to be clear, Mr. St. Croix, and I told your attorneys I was going to speak to you directly. So they shouldn't be alarmed, but I'm doing this. I'm not a fan of semantics. This is the judge speaking to Mr. St. Croix. I don't like when people get, for the lack of a better term, cute, call something one thing and then decide they're going to do whatever they want anyway. When I say I'm not a fan, it's actually one of my pet peeves. I also should let you know, I'm new to the bench. I'm going to be here a really, really long time. So that any violation of this order and any attempt by you to do anything above and beyond what's in this order, if I'm satisfied by the proof presented that you have, it will absolutely unequivocally result in sanctions to you up to and including incarceration. Your attorneys can also tell you, in my former life, I was a prosecutor. I have no problem putting people in jail. I kind of miss it sometimes. So I don't want you to think that you can dance around this or use the words and turn them on their head to do whatever you clearly indicated in your report. I saw you wanted to do from the beginning, and that was to operate a gravel and/or mining operation. That is not going to happen. You're going to be allowed to improve your property so you can make it into a workable farm, in particular, a horse farm. But anything above and beyond that, and anything that I find is being done by you as an end run around, I want you to know this so there's no question in your mind when you leave here today, will be met with very serious sanctions by me. If those building inspectors, the town officials, want to come on your property, they're coming on. They're going to check. If things are too loud and there needs to be some adjustments made, it's going to be done. There will be no question about it. I don't want to have these games later on about, well, this is what was said and this is what was done, okay? Done. You have made, through your attorneys, the affirmative representations that your only intention at this point in time is to run a horse farm. I am holding you to that. I am holding you to that, to the letter of this agreement. Monetarily sanctioned will be the least of your problems if I find that you are stepping outside the very clear dictates of this order. So you need to know that before you leave here today, so that I don't want, when we come back, if there's an allegation and I'm satisfied for you to say that you didn't understand that it wasn't clear, because I want you to be really clear. I want to be really clear with you. And as I have said, it will come back before me. Mr. Lynch will make a note in the files that any motions to a judge in contempt or any alleged violations of this consent judgment will be assigned to me, nobody else. I wouldn't burden anyone else with having to go through this. But more importantly, I know what's happened, I know what's transpired, and I am the one that is going to keep a watchful eye on this. Mr. Conley responds, you may be right, and I don't know whether or not the town council had the authority or whether it should have been the zoning board. That's not before me today. Go ahead. Mr. The judge said that's not before. Go ahead. Mr. Conley, one question from understanding everything that has happened. The court. Yes, Mr. Conley. As it's laid out in my complaint, my clients have deep concerns with the town's interest in actually enforcing the provisions of the consent order and was curious to any ability to add teeth into that regard, because if the town simply decides to look the other way, as it historically has, then the consent order won't actually protect my clients and or really the code of the town of Forster in any way. Mr. Mancini, that's the solicitor for St. Croix. Your Honor, I want to speak to that if I may. The court, yes, go ahead, Mr. Mancini. I know my brother is aware of this, but the law in Rhode Island is very established with regard to who can enforce the zoning code, and that is the town. Private citizens, by way of separate counsel on their own, do not have the authority or a jurisdiction to enforce orders of the town, ordinances of the town, and the zoning code. In fact, there are two parties that can do that. One is the zoning enforcer under the Rhode Island General Law of Zoning Enablement Act, and second, the town solicitor. So it is the purview of the town, by way of the solicitor, by way of the zoning enforcement officer, to enforce this consent order, consent judgment rather, or any other ordinances of the town, including zoning ordinances. So if I think it's not appropriate, or it's not within the jurisdiction of the court to determine that there is not proper enforcement mechanism for this order, because there is, and I think that is very clearly set forth in our law. The court, no, I appreciate that. I'm just thinking it through, and I understand what Mr. Conley is saying. I would presume, by the way, that this would be available to you and your client, so they know precisely what it is that Mr. St. Croix is allowed to do. I also presume that there's 61 and not 60 trucks that the town will be notified. If they don't, as you said, live up to their obligations to enforce the order, there are certainly steps that you and your client can take. I can't, through right now, or what might hypothetically happen down the road, put anything or add any language to this judgment that would somehow give your clients the right, if you will, to try and enforce it or enforce the terms, but they're going to be aware of it. As I said, I don't doubt from everything I've seen that it won't only be the town that's keeping eyes on you, Mr. St. Croix. It will be the citizens of that town, your neighbors, who are making sure that you are being honest about it, what it is that you are intending to do. I'm willing to give someone a chance if you are, in fact, doing what you say you are doing. It might ultimately enhance the property around it, but I don't like being made a fool of either. That's all I really need to say to you. Unfortunately, you weren't here this morning when I was doing my restraining orders to know just how serious I am about that. But your attorney will let you know I am very serious. It's not a perfect solution, it's really not. But my sincere concern when this wholeheartedly is that even if I were to grant you an injunctive release you were seeking, you could be up in front of Supreme Court and they could say that I was totally wrong on all that, and then went right back. And guess what? He's a crushing gravel and doing whatever he wants without these limitations or protections in place. And after a lot more money has been spent by all parties, because it's not exactly the town of North Kingston. I agree with you. It's close enough that it may give me pause, and that's why I thought this was the best of avenues that were available. So as it relates to the town of Forster versus St. 23 LLC, Brian St. Croix, this court has reviewed the consent judgment. I do think that despite the reservations, which once again, I know I have said it a few times, I am repeating myself, they're so well founded, I share them. I just think that this might be the best way to address it. That the provisions outlined here should be enough to ensure that any work being done on the property is being done incidental or as a means to accomplish the primary ultimate objective of that being converting this property to a workable horse farm. If I am wrong, you can all come back and see me and we'll go from there. Because of that, I would say, Mr. Conley, that's why I indicated by virtue of me agreeing to approve and enter to the consent judgment, it does in essence effectively deny your request for injunctive relief on behalf of your client, Richard Sparks and Castle Sparks. Your well-placed, well-founded, and well-reasoned objection is noted for the record. And I'm going to keep my fingers crossed that your valid concerns will be put to rest because Mr. St. Croix is going to do what's being asked of him, knowing there will be consequences if he does not. So with that said, I will wait for the corrected consent judgment. Your objection is noted for the record. Counsel will request your client's request. If there's anything else I need to place on the agenda, Mr. Achilles, no, Your Honor, the court, okay, I wish you all well. Mr. St. Croix, it's incumbent upon you to not be only a good citizen of the town of Forster, but also to be a good neighbor. To the extent of that, has it always been the case? Let today be the first day of a new relationship, okay? Be well, everyone. Enjoy your weekend. Mr. Conlon, thank you, Your Honor. So that, in essence, is the entire court. It kind of brings you through to where we are, where we sat. So I hope that was helpful. I've never read something as long as that in my entire time on the council. And it was...
I just think that it's very important that everyone to
Yes.
see that. It's a matter of public record. You can request a copy of it and have it, and you would do that by going through the town clerk.
I have a copy if somebody wants one.
Yes, Mr. Esposito, would you state your name and address, please?
John Esposito, 126 South Killingly Road, Forster, Rhode Island. And I have the pleasure of being the chairman of the zoning board. I was not appointed by the town council. I volunteered and I was accepted by the town council. And I vowed to do what I could, to the best of my ability, to uphold the laws that were passed down by the town council concerning zoning. And I can say in the last 2 years that I've been chairman, we've made some improvements. I haven't made them, the whole zoning board has made them. Such as we pick up our documents in a timely fashion, we review them, we investigate the laws, we come to a conclusion, and we present them. Now I have a question for you, Madam President. When is the last time that the town council tried to overturn, and I'm saying this, tried to overturn a decision by the zoning board?
I'm not sure, to be honest.
Cell tower.
The cell
Cell
tower.
tower, and then there was another one, Stagwood Road, that went to court and we lost.
So I will voice why I agreed to this with as part of the council. As one member of the council, I looked at what was being said, what was going to cost the town. I looked at what we put in place, which were several things, many of the things that the zoning board had already put in place, and we added things, including that there would be a fine for him. I had to look at what it would cost the town, what we could get best, because as the judge said, if it went on further, if we did not come to a mutual agreement, and it went on further, Mr. St. Croix was going to be able to do whatever he wanted. He was going to be able to call out Saturdays and Sundays. He was going to be able to do anything and everything because we would be at a standstill. I personally felt that this was the best we could do for the town and the neighbors in Forster.
And it was your opinion to call a special meeting that was not a public meeting and make a decision to overrule what the zoning board had judged.
If I may.
say at this time, Horse Farm never entered into the conversation of what was to be done on Mount Hygiene Road. If the town council had taken the time to review the reasons why we turned down Mr. St. Croix, they would find that there were valid reasons. We didn't just come to this conclusion, and it was not just 3 people that voted against it. It was 6 people on the planning board.
That's not correct.
Mr.
That's six,
Savazio, Mr. Savazio, thank
The
you.
planning board has.
Mr. Savazio, thank you.
So,
There were 6 people on the planning board that advised, we don't have to do what the planning board says.
we take it under consideration, because there are 6 members who live in town who have consideration for the town. Now, I want to know why this case is special. Why does not the town get involved with the neighbor that wants to put a septic system within 10 feet of his boundary line near his neighbor's well? The reason for the zoning laws is to control what we do. And in every case, someone wins and someone loses. But we cannot win at someone else's expense. We cannot sacrifice someone else for the benefit of one person, which is exactly what's happening here. We've got 23 people who are abutters. I don't serve the town. I don't serve the town council. I'm neither Republican nor Democrat, but I serve the people of Foster, and I quoted chapter and verse where I thought he was doing something illegal. Not to mention that he's already gone from a gun range to a hayfield. Now it's a horse farm. What came before us was a gravel bank. And if I may read, first of all, I'll read section 38-131. Now this was quoted. This is my work order that I handed in. I just didn't say I want to vote against this man. I backed it up with a work order quoting chapter and verse. The 2 people that voted for it, you know what they did? They circled, I approve. And you know what their argument was? You should be able to do whatever you want on your own land. That doesn't cut it with me. Because what's it doing to your neighbor? Now, he wanted to cut all his trees down. Nobody liked it. Perfectly within his rights to do so. Now, I have been accused of having a vendetta or being mean or tough on Mr. St. Croix. I could care less. But when he comes in and he changes all these things, and he tries to tell me that 860,000 cubic yards of material is incidental, so it can qualify for an agricultural residential qualification. I don't buy it. 860,000 cubic yards. That weighs over 1,700,000 tons. May I read? I'll go back to it.
I don't mean to cut you off, Mr. Esposito,
Yes,
but there are many people that want to speak. We also want to respond to you, and I think if we could just take a moment to respond to some of your questions before we go on.
If I may.
Thank you.
The issue with St. Croix was on the executive session last, it wasn't a special meeting. Any litigation, discussions of litigation have a right to be called an executive session. That's where that was handled. Then when they came back into session, they voted on the consent agreement that had already been worked out between the attorneys. As far as Mr. St. Croix changing from whatever he was doing to a horse farm, as Mr. Conley knows and I know, we're lawyers. And we're hired guns. And so what Mr. St. Croix did is he hired a law firm that specializes in this stuff. I'm presuming, and I don't know if Mr. Conley knows, that they looked at this and said, well, a horse farm is a permissible use. When you get into court, Mr. Esposito, the game changes. We're lawyers. There's a judge. We have to do what we think is best for the town of Foster. We understand the zoning board came to a decision, advisory decision to the town council. However, when you get into the court and the judge says, if I were you people, I would go talk about this. You heard her decision. It appeared to me when Mr. Rogers just read it again, that she was going to allow him to just have a permissible use and open it up as a horse farm. We would have no control over that. We got that idea from the first meeting with her, so we did the best we could with an agreement for the town. We can sit here till midnight and argue back and forth. Once it gets into court, it doesn't matter what anyone does anymore. It's before a judge. They're going to change their mind. So we can sit here and debate this back and forth. No one wants to see that here. No one wants to see a bunch of trees cut down, all of us that live in these rural towns, and see a bunch of gravel being dug out of there. But we had to get what was best for the town. If that went to the Supreme Court and it was overturned, if she gave us the injunction, it's a chaos, it's a free-for-all. There's nothing directed at you guys from our office and you know, you work with Ms. Achille all the time. She's a good zoning and planning lawyer. However, our job is to do what's best for the town. Mr. Connolly's job is to do what's best for his client. Mr. Mancini's job is to do what's best for his client. That's all we do. And you try to put the best before the judge. All we did for this town was to put the best case forward. Now, if we got our asses beat as a town from Mr. Connolly, Mr. Mancini, you'd be chewing me out right now saying, why don't you give these guys better advice? You've spent $30,000. So we can argue all night long on this stuff. The bottom line is that we gave what we thought was the best advice to this council. That decision, when you read it, she was gonna, it seemed to me, rule in his favor. So we did the best we could to help the town to protect them as much as we could. That's what it comes down to. Nothing against you. It wasn't a special meeting. There was no backdoor meeting. It was on the agenda as executive session 2 weeks ago.
My question to the board and the council is why this was tacked on. Now, in my
It
estimation...
had to be tacked on. The judge requested it. We were in order. The judge requested
it. But the initial... I'm sorry? The judges are running the town, but the bottom line is that if we just blew off the judge and said, oh, we're not going to negotiate with anyone, and showed up the next Friday and said, well, judge, we didn't do anything, that's not going to look good. I understand that.
So we got it.
Wasn't the initial lawsuit, if you will, against the town because they didn't uphold what zoning had ordered? We caught him, and he admitted that he was doing something illegal. He was overruling the cease and desist. Isn't that why Mr. Sparks went to
I believe,
court?
Ms. Esposito, the reason we did not initially follow suit is because we needed evidence to back that up. We couldn't just say, we got phone calls from neighbors told us what was going on. Our zoning official went out there, and once we had the documentation that we needed, we went to court. We could not do that prior. We would look like fools if we said, well, we think he's doing. We had to have something to back it.
All right.
Could I ask you to wait 1 minute?
Yes.
You're going to close because I have several people that want to speak.
I understand that. I'm going to close. And I'll just say this. Why am I wasting my time being on the zoning board? I'm 80 years old. I don't need this. I don't have much time left. Why am I wasting my time when this town will not uphold the decision by the zoning board? You can't afford a zoning board. What? I'll give you $8, you go to Staples, you get a rubber stamp that says approved. Comes over the desk, approved. You can't afford a zoning board who wants to do the right thing for the people of this town. I'm done.
Thank you.
Thank you.
Mrs. Cardillo, you had your hand up first.
I have a couple questions. First of all, regarding Mr. St. Croix, there was a meeting held at the South Gloucester Fire Station, and there's quite a few people that were present that are in this room. Feel free to raise your hand. There's a council member that stated at that meeting that his equipment was on that property and his equipment broke. That's why he pulled a paycheck.
This was not.
Let me finish, okay? I sent a personal email to the town clerk's office to Susan Spread. My personal email ended up on the Gloucester Town Council News, and the administrator is sitting right there, so maybe she'll be able to tell you how Mr. St. Croix was able to put it on the website, or Sue Dillon, how it came out of her office.
We're discussing the.
We are talking about this, we are talking
We
about
are
Mr.
discussing
St.
the
Croix.
court or.
My question to you is, when is this town council going to take responsibility and have a mind of their own? It's like the three banditos and you all just follow along.
Thank you, Mrs.
You
Cardillo.
are not ruling our town for the people. You're ruling it to make money in your pockets.
Thank you, Mrs. Cardillo. Eva, could you stand, state your name and
Yes,
address, please?
45 Old Anderson Pike. So, I don't know if this was already part of what you read out, but, so he gets to do his gravel pit, and then he gets to put 5 horses on his land. Is there anything in place for the future to say he has to stick with a horse farm? Is there anything saying this is agricultural, you said a horse farm, it needs to stay a horse farm? Can he change that later on? Legally?
He can come and apply for anything he wants if it fits under the zone. But let's say he wanted to put 5 houses there.
His entire argument has been right to farm.
I understand it. You're asking a question, I'm trying to
So, yeah,
answer.
okay, so what I'm saying is,
If I wanted to sell my motel and the guy wanted to put Cumberland Farms there, yes, I could do that.
but that's not a farm. I'm saying
It's
his whole
commercial.
argument so far has been about the right to farm and that his horse farm is the be-all, end-all of what's going on there. So I'm asking, is there any legal way to make sure that that's what it
He could
stays?
sell it to a solar.
No, I mean,
farm.
he can down the road sell it to someone else who'll do something different. Maybe they can put a, I don't know how much frontage it has, maybe they could put a subdivision in. Maybe they could put solar there if the council is gonna allow that, or whatever. So right now, this is what.
Is that allowed under the agriculture?
I don't know, I mean, I'm just giving you, you're just asking, I'm just throwing out some ideas.
Yes, it is.
I'm sorry, we have one conversation at a time.
Well, so, right now, this is what he's required to do, so, in 2 years, when he gets done with the gravel and he builds the horse farm, I guess in 5 years from now, if he decides he wants to move to Florida and he sells the property, someone else can come in and do something totally different if they have to come here for a special use permit, or they want to put a subdivision in, or whatever, low-income housing, you don't know what's gonna go on down the road. So that would be for another council down the road. Right now, what's before the council in the court, in the ongoing litigation, is this 24-month period that he's gotta do all this stuff, and then 6 months after that, he's gotta have horses on that farm. That's where we're at right now. If he violates any of that, then we're back in court.
And
That's
he's paying for the lawyer.
right, and that's where we're at right now.
But he is not actually sticking with his horse.
Well, I don't know, I mean, when we get to the, yes, he will, so when we get to that time frame, as long as he's there, he's gonna have to stick with that. Now, if he comes before the council, or before zoning or planning, and says, I wanna put up as many houses as I can, well, that's a whole new ballgame. That has to be reapplied for and looked at again.
But is that allowed under?
I don't know, I'm just giving you examples. I don't
He's
know.
entitled to the same rights you are.
I'm not getting the gravel pit.
So we can have a gravel pit?
I'm asking, this is supposedly agricultural zoning. Is he allowed to subdivide under the agricultural zoning?
If you have the frontage and you have, yes, anybody can. He's entitled to the same rights you are if you had that land.
Okay,
Or
so
on-
he could, after all of this, his gravel pit is
Yes.
the horse farm, then turn right around.
And the judge will rule in his
subdivide.
favor again.
That's lovely.
Mrs. Rogers.
Ryder Burgess Road. First of all, I'd like to know, after the 24 months and he's done graveling, is there something that prevents him from just saying, I'm selling, and then
No,
no
that's
horse
not in
farm?
there.
He
That's not
cannot
in
do that.
No, but that's not in this agreement.
Right, so he could
He
just
could
take all the
conceivably
gravel
do
out,
that.
sell it the next day, no horse farm.
Right.
If I may
There's a bond that
interject here,
provides the,
he has to do 10 acres at a time and restore it back. He can take the gravel out, he needs to restore it to a hayfield or a field. And then he can go to the next 10 acres and do that. And then go to the next 10 acres. And he has to, as Mr. Rogers said, he has to be bonded, so if he does renege on anything, the town can go back.
Another question, he has been fined $100 a day since February. Are you going to see any of that money? Or is that part of the agreement that that goes away?
That was not part of the
That was
agreement.
not part of the agreement.
So how are you going to get that money? What's in place to get that money? He could just not pay it. And I think that because of that, that order, that consent order is meaningless. Because you know, yes, 60 trucks a day. Well, who's going to sit there and make sure that it's only 60 trucks a day?
It's 60 trucks a week,
No, you said a day. Who's going to sit there? The zoning official is 10 hours a week. You said you can't go to the court with someone just making a phone call. So is the council going to pay to have someone sit there to make sure that that is being done correctly?
The zoning official has been informed that he will make periodic stops there. And he does not have to announce he's coming, and he has to.
Has he ever had to announce that he's coming?
No.
No, so that is meaningless. That big concession is a big whoop, nothing. $100 a day if it's not a horse farm. How many times in this town have we fined property owners $100 a day and it goes nowhere? Because they never do what they said they were gonna do. They don't, it gets so high that it's like, $900,000, way more than the property is worth. And we will never see.
I've never seen that on any councils I've been on, perhaps when you've been on a council.
Yes, there was.
I think the only one was the solar farm, and that was corrected at point of sale.
No, there have been others. There have
Since
been
I know.
others where the town, this is meaningless. He gave up nothing, absolutely nothing, and this town gave up everything. Now, the solicitor mentioned, it costs thousands and thousands of dollars to fight this. The abutters pay thousands and thousands of dollars every year in taxes. And what are they getting for it? In the charter, the planning board is charged with making decisions that upheld the health, safety, and well-being of the residents. The zoning board, when they make a decision, they have to abide by that. It's right in their rules. I realize there's nothing in the charter that says anything about the council having to make decisions for the health, safety, and welfare of the residents. But I would argue that that should be a no-brainer. We should just assume that that's what's going to happen. That court order gives him everything he wants, and it gives the town zero assurance.
I'm sorry you feel that way, Mrs. Ryder. Thank you.
Well, I like to.
I'm sorry.
I will be
Mrs. Rayo, the gentleman back there had his hand up
I
before
need to
you.
give him that area.
Mrs. Rayo, I will decide your consent. Sir.
Hi, my name is Mark Phillips, I live at 32 East Gilman Road. I've been coming to these meetings since the beginning. I've sat here and watched that man lie and lie and lie, okay? We're supposed to believe this man, like what you're saying, that he's gonna do this? We all know he ain't, okay? The guy came around trying to find goats to get to the back of that property, so he could beat all the other stuff. He is a liar. There's no reason anybody here should believe what he's saying, period. Thank you.
Yes.
One more person, Mr. Ray. Mr. Conley.
So, I've heard a lot of discussion to the effect that going this route will save the town legal fees. I can assure you that is incorrect, because it does not resolve my lawsuit against the town.
Thank you.
In fact, the addition of the
I don't think that's what was
consent
said.
order will be an additional claim, so you will not save any time in court or any legal fees.
Thank you for the warning.
I
Mrs.
just-
Rayo.
Okay, my contention to this is, it said 860,000 cubic feet of gravel will come out of that land,
Yes.
out of the 10 acres. How much value does that gravel have, sir? Does anybody know how much the gravel costs in one truck? Maybe he will know. Because that's a lot of money which comes out of it. And the town doesn't get paid for whatever. And the neighbors may lose their well. So there is something I think the town council needs to look into it, to get some money out of the 860,000 cubic feet.
Thank you, Mrs. Rayo. Moving on, I do not see any more hands up. Did anybody from the council want to say anything further? Thank you. I'm glad we got it out in the public so that it can be put to rest. Moving on, we have the Vietnam Memorial Moving Wall invitation. I was sent this. I'm going to ask that if you need to leave quietly, please, because we're doing
whole paragraph?
Okay, moving on, the next item is the Vietnam Memorial Moving Wall invitation. I did receive this from Mr. Stanley, who is a history teacher, I believe, a social studies teacher at Pontiac High School, and as we know, they are doing fundraisers, etc., to get the Vietnam Memorial Moving Wall to Pontiac High School. They are looking to have a parade and escort on Thursday, November 1st. It says 2016, but it is 2018. I don't see a need to, I just wanted
I
you all to be
think
aware.
we need a motion to, if you would want to authorize the waiver.
I did not authorize anything, I just wanted people to know that if you wanted to be in the parade or be part of the escort, to contact Mrs. Dillon to let her know that you wanted to be part of it. So then she can let Mr. Stanley know on hold that we're attending. Moving on, Providence Water settlement payment. This was Ms. Ross.
I wanted to point out, because I'm concerned that this is gonna get away from everybody.
If we ignore the last payment and don't address it, it's gonna slap us pretty
So
hard.
Yes.
I point this out like once a year, right around this time. As you can see, I did that amortization schedule of the bond. What happened was when we originally agreed to the settlement,
It was an end balloon.
it was based on prime rate also. So there's a few components to this. It was based on the prime rate at the time.
Thank you.
We signed this agreement sometime, I believe, in 2015. At that point, the prime rate had changed in 7 years. Since that time, the prime rate has changed about 8 times.
Good or bad?
And it's only gone up. So we went from a rate of 3.25, we are now at 5%. So as you know, if you were gonna get a house, a mortgage, or a car loan, the difference the interest rate makes is pretty significant. So, we have done our due diligence, we started out at 175,000, we did increase it to 190. If you recall during the budget season, I said that we really should fund more, but this, as we went to the cap, was not the year to do it. So when I looked into this calculation of the amortization, and what the payment of $190,000 will leave us with going forward, you'll see the balloon payment in the final year. I'm sorry?
$289,936.
So, I mean, obviously, you don't want to have to raise $100,000, and I don't see the prime rate. If you look, you can see all the changes in the rate. So it changed 3 times this year, so I had to do this amortization schedule to show the change, because they want it day to day, believe me. So if it changes on June 15th, they want the interest, higher interest from June 15th till July 1st. So it changed this year 3 times. It changed last year, I believe, 3 times. And there is no sense right now that the rate will go down, only up. So when I looked at the prime rate, the history of the prime rate, it's been as high as 8%, currently we're at 5%. So I think it's important next year, and as you know, I won't be here to do the budget, I might pop in just to make sure everybody doesn't do something that I'm so against, but I would like to see that you increase the payment. So I calculated some rates and different ways that you could fund it, and I think that by funding it approximately, let's see, increasing the rate.
You didn't give us copies of that.
No, I have like 8 different pieces of paper, like it's kind of, I think I raised it to say 210, by just doing the 210,000.
From 190 to 210?
So just by doing the 210 with this, if the prime rate levels and stabilizes, you should be fine in the final payment.
So we're gonna have to commit to that next year in the budget
I would
workshop.
say that you should at least commit to that. Somebody's gonna have to calculate this next year, it can be a little complicated, but it's not. It has to be calculated. At that point in time, look at the prime rate, if it's continuing to go up, you might wanna do 215. But at least do 210, so somebody should make a note of that.
Is that only on principal?
That's the principal
That-
of the
that's
interest.
the principal.
It goes, it will, no, the whole
If you
thing.
increase it doesn't matter, if you increase the payment.
No, it decreases future payments, because I did it all the way out. I did a calculation of it all the way out. Amortization schedule. So that's my recommendation. I didn't want to let this time go by knowing, first of all, you should see that your liability is growing, even though you're making your scheduled payments. Because that balloon payment was never addressed. We did increase 175 to 190, that did do that was a big jump, it was a big help. But if you don't increase it again, you're gonna be stuck with a balloon payment that nobody's gonna wanna pay.
It happens in a good economy.
But it's so funny, because everyone felt like it was a good risk at the time, although we didn't have much say in it. But the primary hadn't gone up for 8 years.
Well, the agreement was a prior agreement that was shelved, and they agreed to the original agreement back, or we were gonna go to court and spend thousands and thousands of dollars for something that was already lost in another town.
Yes. So that's where you're at. My recommendation is you increase that payment and look at the prime periodically just to see where it's going and think along those lines. You don't want to have to raise $100,000 in that final year when your cap has been reduced to less than 4% when you take out the motor vehicle phase out. You don't know what's going to happen with that, and that could be a really big deal for you at that point in time, and I just think you have to plan ahead.
Thank
Okay?
you. Thank you for doing that.
You're welcome.
Moving on, we have future agenda items.
Coleman plan. Remember the Coleman plan? No, I mean the IT thing.
Yes,
That.
we have the Henry Phillips Recreation Field, Route 101 Solar Farm presentation, which is Quahog Solar. Wright's Auto Parts is on the 12th, and the communications/technology.
I'd also like to add Central Pike Bridge discussion action.
Central Pike what?
Bridge.
Okay. To the next agenda item, or?
Yeah, I think we gotta definitely start working on discussing that. How we got where we got and where it came from.
Okay. Anything else? Okay. That being said, I take a motion to go into executive session.
Motion to go into executive session. I will make that now. I move to go into executive closed session pursuant to Rhode Island General Law 42-42-4 for the reasons stated in Rhode Island General Laws 42-46-5, A1 personnel, A9 International Association of Firefighters Local Union negotiations, and A5 Libraries of Force. Discussion of action. Second.
Discussion, hearing none, all in favor? Aye. Opposed? I'll take a short break.
I just got a question.
The cover bridge. Well, we'll have it on the agenda.
It'll be on the screen.
I'll let you know if they beat me up on the way by. Actually, I'm going the other way.
On Route 6, we got.
Spring of 2019.